relationship with the court. Are there things that you would like people in the United States to understand about this relationship, where you're going with it, or what it should tell us about what the court is like, what it should do for our comfort level about the court? I'm thinking about Americans, for example, who have at least a high passive support for the court. And of course, you always have to think about Congress in connection with something like this.
Right, right. No, we want to do what we can, but consistent with our law,
yes,
to help the court succeed in these situations that it's taken on that are clearly, as I said, cry out for justice. It is important to understand that we do have laws in the United States that are still on the books. There's a 2001 law that says the United States can't directly fund anything in the AMICC. There's the 2002 law, the American Service Members Protection Act. By its title, it's focusing on the concern in the Bush administration that Americans who might be called on to protect people from atrocity or terror might end up, being prosecuted. As I say, the situation where there's a warlord who kills 20,000 people, and we come in to stop him, and a shell goes astray, 20 people are killed. The concern was, well, the prosecutor would say, I'll be even-handed, I'll prosecute the warlord, but then we'll prosecute the American colonel, etc., that was in charge of the unit that lobbed that mistaken shell. Of course, that wouldn't be a very strong case, because it would be an intentional attack, etc. But there was that concern that our people could, by someone who wants to score points and say, I've got an American and a slammer, come after us. So that was the concern that responded to, and that's why it was called American Service Members Protection Act. And it did prohibit, by its explicit terms, a variety of kinds of assistance to the ICC, responding to mutual legal assistance requests, allowing investigators to conduct investigations on American soil. There were a number of things that there were some waivers that the president could use. But it did include an important amendment by Senator Dodd, now outgoing senator from Connecticut, whose father, who was the senator before him, but before he was a senator, was essentially the deputy to Robert Jackson, Justice Jackson, the prosecutor at Nuremberg.
That's been important to the senator all his life.
Yeah, the most effective members of the American prosecution, one of the most effective members of the American prosecution, real experience. Courtroom advocate and cross-examiner. Very proud of what he did there, and his son's very proud of it. And Senator Dodd fixed an amendment that said, nothing herein shall prohibit U.S. assistance in a case involving a non-citizen, such as Osama bin Laden, Saddam Hussein, Slobodan Milosevic, or others who are alleged to be responsible for genocide, war crimes, and crimes against humanity. So that particular provision, at least dealing with cases, not just general court support, but with cases, gives us some flexibility to assist the court when we've got sort of serious violations and an individual possibility to go out there and help. Now, people could say, couldn't these laws be changed? But I mean, at this stage, we want to use what's there, consult closely with Congress, and it's generally our perception that when we talk about cases, congressmen of both parties are very supportive of justice for and very supportive of justice in the case of
we have this legislation about Uganda.
Yeah, exactly, which had support, it's co-sponsored by a very progressive Democrat and a conservative Republican. So,
yes.
And so and when we were, to step aside from the ICC, but in the Special Court for Sierra Leone, my predecessor went to Congress and got a resolution, I think, passed 434 to 1, calling for the surrender of Charles Taylor.
Yes.
So when you talk about individual cases and you say, you think we should arrest Conan, absolutely. Where should we try? Well, we're going to, the ICC's indicted. They should do it, and they should succeed, etc. In the DRC cases, in these warlords, should they be, should they be arrested? Should they be tried? Absolutely. And Americans are, see the victimization, see the horrendous crime, they want justice. So I think that kind of support, builds a real, and then if the court is effective in those cases, I think that builds some confidence. Now, at the same time, from a purely, by having a good relationship with the court, if there are issues that get raised about America, we're in contact with the court and can respond to those, etc. So it's much better, I think, to be engaged than to be disengaged.
You have an open channel that can go both ways.
And of course, it's been, I think, very valuable when you get into this controversial area of aggression, maybe, but that we were able to go and talk really about two things. One, about supporting the court on genocide, war crimes, and crimes against humanity, and two, indicate that the court should be cautious about moving forward with aggression before it dealt with being effective on these other crimes, and move forward with aggression in a way that recognize that there are situations where force needs to be lawfully used to protect people, and we should be very careful to make sure that we're talking about the kind of things that we prosecuted at Nuremberg, with aggressive war, and not with a court that would be involved in prosecuting someone who is involved in humanitarian protection or involved in other action to deal with terrorist groups that are crossing the borders and they follow them into the other country in hot pursuit. Is this aggression? I mean, we don't want this court to be entangled in that kind of thing.